Hi everybody, my name is Jeff Fowler. I'm with the Apartment Owners Association of California. It is great to have you with us today, and we are going to have a legislative update on 2179 and how it's changing things for you or not changing things for you, and specifically for Northern California. And we have our speaker today is well-versed in Alameda County and will be able to answer questions for you and give his interpretation of the law. Not necessarily the perfect advice for you, because lots of times just practically it takes knowing more and to be able to answer questions really well. So when you do ask questions, always put where you're at, how many units you have, or how many units the building is, because all those things make a difference. But anyway, the Apartment Owners Association of California, and really there are so many benefits to joining. It's only $97 a year, which is just not much at all, considering that you get the forms. You can call in and ask how to use the forms, or what rights you have as an apartment owner, and we can refer you on to a attorney for sure. And also you get the monthly magazine, and there's the access to the tenant screening. And also we have the property management software, the AOA Digital, and this has been a great tool for people to help them do their taxes, and then also some of the other things like the online rental agreements and making online rental payments setting that up for their tenants, and a host of other things. It does connect with the AOA membership program as well, and so that's been great. So lots of resources, insurance, group insurance for everybody. There's so many different things that you can be a part of, and so we want to encourage you to join. And also, even with all of that, your first year, it's 100% money back guaranteed, and so there's really nothing to lose on that. And just a little bit ago, we had a live stream about how to attract 67% more potential customers or applicants for your next vacancy. And so this is something that's free. The advice is free, and also to implement that advice, it's free. It just takes time, and not even that much time at that. So you're going to want to watch that. A couple weeks ago, we had a live stream about resident manager litigation. We had a resident manager attorney, and we had an attorney that represents owners, much like our speaker today that would represent owners. And anyway, they had a great discussion, and all of us learned. So if you have a on-site manager, you definitely would want to tune in and just make sure you have all your T's crossed and your I's dotted. And next week, we have a live stream about 1031 exchanges into the DST. And many of you know about it already, but if you don't, this is a way that you can avoid capital gains tax if you're selling your building. So that could be interesting for you. With all of it, we want you to subscribe to our free e-newsletter. It is at aoausa.com, and if you go all the way down on the right side, you can sign up for that letter. It's free. And anyway, so definitely want to encourage you to do that. And for this video, if there's information that's helpful for you, share it with other apartment owners that you know, and we'll keep everybody in the know that way. So our speaker today, he has 30 years of experience. He's the founder of Beckman, Feller & Chang. His firm represents the 7 Bay Area counties, and he's actually done the legal Q&A for Northern California for over 10 years. And what we'll do is we'll put a little link into the bottom that'll link to some of his articles. And his articles have they are always spot on. And we end up referring people to those all the time just because they're relevant. He has great timing. And anyway, so it's my pleasure to introduce you today, Rich Beckman.
Good morning, ladies and gentlemen. My name is Rich Beckman, and as I'm sure Jeff Fowler just introduced me, I'm an attorney who's been practicing landlord-tenant law for about 32 years, primarily in the field of real estate with an emphasis on landlord-tenant, with an emphasis on residential rent control, primarily in the Bay Area, San Francisco Bay Area counties and cities. Originally, of course, those cities were San Francisco, Berkeley, and Oakland, but rent control and eviction control is spread pretty much to every major city around the Bay. And then, of course, there's the statewide rent control and eviction control. But we're here to talk about what's identified as the state eviction ban extended, the Northern California legislative update. First of all, thank you all for attending. I'm sure Jeff and AOA appreciates every member being here today. But I would note that I don't think state eviction ban is quite exactly the right title. I might have changed that. I hadn't noticed. It's really more procedural continuance. But before we can really talk about 2179, the state statute that took effect April 1st, it's really important to kind of go back and review what happened before, because really 2179 basically just builds on and extends the prior legislation with some changes. But that's what we're here to talk about. So I'm going to try to share my screen now, and I hope you'll bear with me on technological challenges, but I'm sure AOA's Master Tech, Israel Pareto, will have us all going here in a moment. So stand by. All right. With any luck, you're now looking at a PowerPoint presentation. That's State Eviction Ban, Extended NorCal Legislative Update. And so I'm just going to proceed through this. It's a fairly short seminar today, I think about 20 minutes. So this is in many ways a repeat of a previous presentation that we gave back in October of last year. So I'm just going to go through it pretty quickly. The topics being the AB 2179, Alameda County update, and San Francisco update, because this is the Northern California sort of area. Brief review of state law, and here we go. So this all, going back in time, it's hard to believe how long it's been, but AB 3088, sort of the mothership of the statewide effort to bring some measure of uniformity to what had been a hodgepodge and a potpourri of local ordinances that were attempting to deal with the tremendous impact of the pandemic beginning in March of 2020. So it took the state a few months to sort of put something together, and what it put together was AB 3088, the Tenant, Homeowner, and Small Landlord Relief and Stabilization Act. I'm sure the landlords wonder, where's our relief? The tenants certainly got some, but so this biggest thing it did was it required landlords to give tenants 15-day notices of rent default rather than a 3-day notice. So that was a primary change. But along with the 15-day notice, the impact on unlawful detainer cases, because previously, of course, the landlord could serve a 3-day notice, and if the tenant didn't pay the rent, the landlord could immediately go to court, file an unlawful detainer lawsuit, an eviction lawsuit, have it served on the tenant, and move the matter through the court process. AB 3088 basically put a halt on all that and just said that unless the tenant had already been guilty of unlawful detainer before March of 2020 or failed to comply with the new rules in AB 3088, or the unlawful detainer was based on something other than non-payment of rent, the court could not find the tenant guilty of unlawful detainer. And then, of course, I have in big red letters the concern that local ordinances were also in effect that expanded the statewide protections beyond just non-payment of rent, and in some cases to any form or any basis for evicting a tenant other than a public health and safety threat or the state Ellis Act. So the 15-day notice, depending on when the rent came due, there were 3 different periods of time. The overall period of time, called the covered time period, is the time from March 1st, 2020 through September 30th, 2021. That is basically the entire spectrum of the covered time period. Within that time period, there were 2 different time periods. The protected time period, which was from the beginning of the pandemic impact of March 2020 through August 31st, my birthday, 2020. And in that case, tenants who were served a 15-day notice were also given a declaration that they could return that stated that they couldn't pay the rent because of something related to the pandemic. And if they returned that declaration within the 15-day period, they could not be evicted for non-payment of rent. The rent would still be due, but it can only be collected through some other process, typically what we'd call a collection action, a small claims lawsuit or a regular Superior Court lawsuit, depending on the amount. So that was the protected time period. Then came the transition time period. This was the period from September 1st, 2020 through September 31st, 2021. And this allowed tenants to return the 15-day the declaration with the 15-day notice to avoid eviction if they pay the unpaid 25% of the unpaid rent no later than September 31st, 2021. The rest of the rent, just like in the protected time period, was not waived. It could only be collected, though, through a independent collection action. So that was that period. Then came up a brief note for what are called high-income tenants. Because other than high-income tenants, the tenants simply could return the declaration. There was no requirement that they produce any evidence of impact of COVID-related financial impact. But a high-income tenant, somebody who made a certain amount of money, 130% of the local median income, could be required to produce proof that they were impacted by the pandemic, and that's why they couldn't pay the rent. Now, it's very important to note that the landlord had to have proof of the high-income tenant before they made a declaration that they couldn't pay the rent. Basically, the only way a landlord would have that was from the tenant's application that showed their annual income. Because if a landlord alleged that a tenant was high income and didn't have that existing prior evidence of the income, there were consequences for that. So and I'm not sure it came up much. I really didn't see much of it. So, but it was something always to be aware of. Because again, if you had that evidence, primarily from the application, you could compel the tenant to produce actual evidence that they were impacted by COVID rather than just simply saying it. So the original AB 3088 was going to expire at the end of January of 2021, and the legislature decided there was still enough impact that wasn't a good idea, so they passed SB 91, the Tenant Relief Act. Now, this basically did almost the same thing as 3088, but it added something significant, and that was establishing the state's Emergency Rental Assistance Program. And that rental assistance program provided that tenants who qualified would have 80% of their rent paid to the landlord by the program. It added some other little issues, none of which seem to have been very significant. But for example, if the landlord pursued the tenant through a collections agent or a small claims court, the court could limit attorney's fees awarded to the landlord. It could also reduce the amount of damages given to the landlord if the landlord had failed to cooperate with the rental assistance program. It was the biggest complaint most landlords had with it, though, was not in addition to its cumbersomeness, was that it required landlords to accept 80% and waive the remaining 20%. And, that's a significant bite. And for a lot of landlords, I think that was a difficult challenge. But as those previous slides showed, if the landlord didn't participate, basically the court could sort of penalize them for not doing so. So the landlord was pretty much stuck between the rock and the hard place. If they wanted to get rent, it was going to be pretty much limited to 80%. So that went on for a little while. And then as that law was about to expire in June of 2021, the state passed what most people consider to be the final version. That was AB 832. In its biggest change, it guaranteed landlords 100% of the unpaid rent through the program if the tenant qualified. Now, again, the tenant has to qualify in each of these cases. If the tenant doesn't qualify, then the landlord had the right to proceed to the unlawful detainer process if other conditions were met. For example, the tenant didn't pay 25% through that transition time period, or all the rent after October 1st, which we're going to get to. And that was the AB 30. So there's your sort of reference to how much the eligibility requirements, the reason or the uses for the funds that were made available to the tenant, basically rent and maybe some utilities and then any other expenses. I'm not really sure what they included there. Non-payment of rent eviction cases. So this is what we discussed just moments ago, the protected time period. And in that case, if the tenant submitted the declaration, that was the end of the unlawful detainer procedure. The tenant was protected from eviction. The transition time period, again, talked about that earlier. If the tenant paid at least 25% of the unpaid rent that had been subject to the 15-day notice, they were also protected from eviction. Again, the rent was still owed, the remaining rent still owed, but the tenant would not be subject to an unlawful detainer proceeding. And that was the primary goal, was to keep tenants in their houses, in their homes. But again, as we've seen going through, they were increasingly called upon to contribute from 0 to 25% to the next section, which is the transition time period, which we're going to get to in a moment. But after September 30th, the AB 832 provisions rolled back a couple of things. Primarily, it allowed landlords to proceed on a 3-day notice again instead of the 15-day notice. It required, though, the tenant to pay the full amount of the rent so that they were no longer allowed to just pay 25%, but it required the landlord to submit a request for rental assistance. And that had the impact of, as I was just saying, I'm kind of getting ahead of myself a little bit, but yeah, so tenants can no longer just submit a declaration of distress, and those who didn't pay the 25% by the end of September would be subjected to eviction under the unlawful detainer procedure. So when it says end of the state's eviction moratorium, that's pretty much what that referred to. Really kind of anticipated a wave of unlawful detainers. I mean, the courts have been slow, but I haven't really seen that deluge, possibly because of the requirement that the landlord submit the request for a repayment under what's called the recovery period rental debt. And that's rent that was due from October 1st to March 31st, 2022. And so landlords who were seeking unpaid rent during that period of time could file an unlawful detainer, but they had to establish a certain level of information for the court. And that was primarily that the landlord had given the tenant at least 3 business days, and the notice included specific information, which we're going to talk about, and that if the lease was negotiated or negotiated in a different language other than English, the notice had to be translated as well. The notice had to include, and this is a little different from prior 3-day notices, the amount and the date of each amount became due. That's new. And then the biggest thing was the pertinent government rental assistance program information. And then the notice that the tenant could potentially delay or avoid eviction if they submitted an application for assistance. And if the 3 days expired without payment from the tenant, then the landlord, because obviously the tenant paid, case closed. But if the tenant didn't pay, the landlord had three options to proceed with an unlawful detainer. One, a statement under penalty of perjury that they had completed their application for assistance and had received a final decision from the rental assistance program denying the application for the tenant or the property at issue. So that was option 1. And that just meant that the tenant didn't qualify, generally speaking. Now, a final decision was either that it was an approved application, in which case the landlord was going to get paid, or it was denied because the tenant was not eligible, no more funding, or the tenant failed to complete their part of the application within the 15 days of the landlord completing their portion. Now, how this is all worked out in practice has not really been very clear. There's been a lot of frustration with the emergency rental assistance program, but the statute's pretty clear that if there's any indication that the tenant has applied, then the landlord cannot go forward. And it's worth noting, final decision does not include the rejection of an application as incomplete or improperly complete by the landlord, notification that the application is temporarily pending further action by the program or the applicant, or that either applied to the wrong assistance program for the property. And that had to do with, if you had any experience with this, you would go to the housingiskey.com website, put in your property address, and then it would direct you to whether the state was administering the relocation assistance fund, not relocation, rental assistance fund, or whether the local jurisdiction, whether it be a city or a county, had decided to take that role. And the state statute allowed cities or counties of over, I think, 200,000 to create their own program to administer the assistance. I think some started and found out it was so complicated, they just turned it back over to the state. So, the whole thing has been, not unsurprisingly, when you're trying to roll out a major program dealing with billions of dollars, and in some cases on good faith, and the state had recently, experienced a debacle of, workers' compensation claims or unemployment insurance claims, and they were had found they had sent billions of dollars to fraudulent claimants. So there was a much tighter scrutiny, I think, on the rental assistance programs, but that also ends up slowing it down. So the second option, and this is the one that has been used, I think, by me at least more commonly, is that the landlord submitted their application. You always have to submit your application. And then 20 days have passed since the later of the date the landlord submitted the application or the date that the landlord served the tenant with a 3-day pay or quit notice. Now, ideally, an organized landlord or his or her attorney would serve the 3-day notice and submit the application at the same time so that those 20 days runs concurrently. I mean, that would be your most efficient way to go forward. Secondly, the landlord have to declare under penalty of perjury that they have not received a notice or verification from the assistance program indicating that the tenant has submitted a completed application. So basically, if you submitted your application and after 20 days passed, you didn't get word that the tenant had done their part, then you were permitted to go forward. But also that you received no communication from the tenant. And this is kind of the wild card, because tenants sometimes don't seem to have been able to complete their application. Either they didn't have computer technology or whatever the case may be, but they let the landlord know they were trying to apply. And that would make the landlord not able to verify that they had received no communication from the tenant that the tenant has applied, because apply can mean a lot of different things. And then the third option is that the tenancy began after October 1st. So tenants who moved in after October 1st of 2021 were not covered by this protection, and a failure to pay a 3-day notice would result in the landlords being able to go forward with the unlawful detainer. Now, it's important to know that the court just simply can't issue a judgment until it finds that these requirements have been made, that the landlord submitted their application and that it was either denied or the tenant failed to complete their portion. And if the tenant contests whether the landlord has done its part, then the landlord bears the burden of proving to the court they met those requirements. And this part of the statute also allows a tenant at any point prior to the sheriff, locking them out, basically, that they have been approved for rental assistance. And whether that means they applied later and missed the 15-day deadline for one reason or another, but they finally got some, if they could show that at any point prior to the sheriff coming out, then they could stop the eviction. And let's see. And here we are, AB 2179. And basically, it did a couple of things. It continued the requirement. Well, all of these provisions were going to end as of March 31st, which meant a landlord on April 1st would be able to file an unlawful detainer, would not have to verify under penalty of perjury any of those things about having submitted an application or whether the tenant's application was pending. All that was just going to simply evaporate. And really, the legislature began to get, I think, inundated with information that there were thousands, if not tens or hundreds of thousands of applications still pending with the rental assistance program that could protect the tenant from being evicted if it were granted. But if the program were not extended beyond March 31st, there may have been a lot of tenants evicted who were actually going to get assistance if more time had been provided. So that's what AB 2179 primarily does. It extends that the opportunity for the tenants request for assistance to be completed out to June 30th. And so, but the same thing that the landlord must, even if you're proceeding on rent that's due after April. But it's important to note that down here, the important part, that no more applications will be accepted after March 31st. So that the tenant's opportunity to seek rental assistance terminates as of March 31st. If they don't have an application in place by then, the deadline, the window is closed. So, and this is kind of interesting. It also extended the prohibition, or what I call preemption, of local ordinances, which was also going to expire on March 31st, and extended that preemption through June 30th. And this is the thing that basically says no local jurisdiction can create a law that provides additional protection to tenants. If it does, it will not take effect until July 1st, 2022. This was going to expire as of April 1st. And there were several local jurisdictions that were prepared to provide additional protections. And so on part of the program, it had, I think, the Alameda County update. Really, nothing has changed in Alameda except for the fact that a group of property owners filed a lawsuit in federal court seeking to invalidate both the County of Alameda and the City of Oakland's blanket eviction moratoriums. They're really the only place left that I know of, certainly in Northern California, that has, many jurisdictions instituted blanket eviction prohibitions. They all included an exception for the statewide Ellis Act, which gives the landlord the right to go out of the rental business without any reason or justification. But they also had an exception for threats to public health and safety. But slowly or less slowly, all the jurisdictions except Alameda County, and which includes Oakland, Berkeley, Fremont, Hayward. It's a large swath. It's somewhat like Los Angeles County includes Los Angeles City and tons of other places. So Oakland, Alameda County's moratorium affects a tremendous amount of property owners and their tenants. And I have been perplexed how they can continue to justify this blanket prohibition on evictions for all causes except public health and safety. So finally, somebody brought an action to seek to have that invalidated as really as an exercise in government overreach. And so without going into the constitutionality of things, that's basically the argument. But I'm going to go back to say that they haven't gotten a stay, unlike the one we're going to turn to in a moment. So as far as I know, both ordinances remain in effect because the court has not ruled on a temporary ban on enforcement. Unlike in San Francisco, it had created a couple of ordinances that it intended to take effect. One was an ordinance that required a 10-day pre-notice notice. Now, those of you who've been in Oakland, are familiar with this, and it just basically says before a tenant can be subject to a 3-day notice for a breach of lease, they have to be given a pre-notice notice. And this has been in place in Oakland for several years, maybe 10. And finally, it made its way to San Francisco, and it's a 10-day pre-notice notice. And that basically says that before a landlord can serve a 3-day notice for anything, including non-payment of rent, they have to give the tenant a 10-day warning notice, basically. But that particular amendment was challenged by a group of property owners in San Francisco Superior Court, not federal court. And that San Francisco judge issued an order staying that 10-day warning requirement pending a hearing on May 17th. And the court then will hear additional, more detailed arguments by both sides, and then we either continue it or dissolve it. The case is set out there. I won't repeat it, but you can find that, and you can look online and you can keep track of that yourself, see how that goes. Should be very interesting. And San Francisco, and this is sort of apropos of the provision of AB 2079 that continued the preemption of local ordinances trying to provide additional COVID-related protections. And this one says that a tenant could serve even after April 1st for unpaid rent that it was based on on COVID, based on the pandemic. So that would have been another basis for the tenant to avoid eviction for non-payment that's simply not available under any of the state statutes. But because it would have taken effect was supposed to take effect April 1st, but because of the continuation of the preemption provision of the state law, it should be, you never know with San Francisco, they may try to power through or something, we'll find out, but should be stayed at least through June of 2079. Whether or not anyone will file a suit to challenge that particular amendment is unknown. Those are deep constitutional issues involving state law versus local law that a little bit impossible to predict. So that's basically 2179. That's your update. And I think we can now turn to questions. I think, Jeff, I'm going to stop sharing my screen and go back to Jeff.
Hey, look at that. Look at that. Great job.
Did it?
Thank
Did it
you.
all work?
I think so. I see you just on the screen, so that's good. All right. So we're going to give you guys some time to put in your questions, and also just remember to say where you're at exactly, how many units you have, what you've done as far as what's been done as far as applying for COVID rent relief, and anything else that they should mention in there to help you answer questions. Okay, can you hear me? Rich, can you hear me?
Yeah.
Okay,
I'm
great.
Standing by.
Okay. No, I was asking you, is there anything else that they need to include in their question that'll help you?
No, the location is the primary key.
Okay, great. And so before we get started, just make sure you put those questions in right. But the AOA Digital is the sponsor for this. So we're going to have a quick drawing. We're going to spin a wheel with everybody that registered for this live stream. So go ahead, pull up the wheel if you can. And whoever wins, you're going to get a year and a year subscription. If you're an AOA member, you already get 6 months free. So you would be getting a year and a half, basically, if you do win this. And so we'll go ahead and spin it. They spun it. Let's see where we're at. Okay. Natalie, it looks like Zizko, Zuzko or Zisco, I can't see it because it's so far away. But congratulations, you won. And basically, AOA Digital is property management software. At the core, it does the accounting. And so you can keep track of income and expenses, then also cash inflows and outflows. So we have operating income and expenses, and net inflows or inflows and outflows or non-operating. And so it's a great way to keep track of everything. And also it has other stuff like, tenant portal, paying your rent, letting them pay their rent online, things like that. So that's just another tool for AOA members, and hope you guys take advantage of that one for sure. And so here we go. We're going to get to it. Oh yeah, and just to say, I didn't mention it, but we did have a representative from Housing is Key come and speak. I don't know if you saw it, if you noticed that, but she shared a lot of information, and even why they've been so unresponsive and how they're adding more people and how they're expecting, there's over 150,000 applications that need to be processed, and they're hoping to do about 10,000 a week and finish nice and neatly at the end of that time period here where 2179 would expire. And so you may want to go back to that. On YouTube, you could YouTube and just search AOA USA, and that'll come up. You'll see that. And she gives timelines, like people would ask great questions like, I've been approved, when am I going to see the money? Or, it says this, when I go into the portal, it says this kind of message is coming up. What does that mean? And so that was really informative. You guys can go back and watch that. And even just at 10 o'clock, we had one about how to attract 67% more applicants. And really the key is getting the best applicants into your property, because your property is really worth what your tenants are paying. And this is a painful time for a lot of us. And so you want to get the best ones. So you may want to watch that video. It's free. And even the way to get that 67% is free. And so there's a lot of things that we can do. We're in a brand new age that's digital, that there's just amazing things that can be done. So here we go. On YouTube, we have CAT, Alameda County, Castro Valley. It's a fourplex. How do you get around the ban? I have a tenant that paid rent through COVID. She is working, but she failed to pay her rent since November. We supplied information for the tenant in December to get rent assistance, and we haven't heard anything back from the program other than to be patient. So Alameda County, what can they do right now?
Be patient. I don't mean to be cavalier, but again, until the Alameda County ban is stricken, the Alameda County, I think they are supervisors as opposed to a council, just seem to demonstrate no indication that the state of emergency upon which the moratorium is based is in any hurry to be lifted. And again, I mean, I've told every client and member that, is you got to reach out to those elected officials, because they don't just represent one constituency. They represent, the entire population of their location, which includes the property owners. And again, the justification for keeping that ban in place, I cannot fathom it. But they seem to have gone underground. But, they're elected officials. They're accountable. At least they should be. I mean, I kind of jokingly tell clients sometimes if I had property in East Bay, I think I'd go do a hunger strike in front of the board of supervisors, front door. Just some pressure, legitimate, pressure, not the improper kind, but lawsuit, unless you get an immediate stay like the San Francisco case occurred, which didn't appear to be the case in the Alameda County Oakland case. That'll take a year. Those things move slowly. Let's just say.
Right.
So again, sorry, but yes, be patient.
Right. So we're talking Alameda County, Alameda City. Those are slightly different, but yet both of them are covered in a full blanket ban. Yeah,
it's important to note that there's a lot of confusion. The Alameda itself is a town in the county of Alameda. And just like Los Angeles is a town or a city in the county of Los Angeles. But they're not coextensive, unlike San Francisco, which is a city and a county that extends to the exact same border. So it's the only place in California that the city and the county are exactly the same territory-wise. Alameda County is a big county in the East Bay, and it includes Oakland and Berkeley and Fremont and Alameda, the city, Hayward, unincorporated areas. Normally, county laws don't apply in incorporated cities, in cities. It only applies in the areas that don't have another form of jurisdiction like a city. But this ordinance, and that provision probably is questionable itself. It applies to both incorporated and incorporated areas of Alameda County. So if a local city decided it didn't think that a moratorium was appropriate anymore or necessary, then the county blanket would descend and reimpose it. So Oakland has its own, Berkeley has its own, and I don't even keep track anymore of all the other local jurisdictions, because if the Alameda County version applies, it doesn't matter if there's a local one or not. So,
great. And guys, so yeah, we're going to organize at the end of April and have a time where we all call in to everyone, but I would say call every day until this thing's over. Email every day, just spam people, because we have to stand up, and it's gone beyond. This is not a health and safety issue.
I think phone calls, I don't know. I've never worked inside government as like a staffer, but I've read enough that the staff relay the pressure that they're getting from the constituency to their bosses, the elected official, and says, hey, we're getting 500 calls a day on this or whatever. If that doesn't have an impact, I just don't know who these people are and what they're doing. So if you have time, please call every day if you can, if you have time. If you don't have time, call once a week. If you don't have that much time, at least call when we do a campaign at the end of April, and
there's a article that'll be in the magazine, and we'll link to that article down below here so you can take a look at that. We have talking points too. If you're like, gee, what do I say? And what we're trying differently this time is that we know that they really don't care about us as housing providers. What they care about is the tenants, because the tenants are the ones that they're looking for. They're looking for their vote. And so some people may disagree with that. That's just kind of where the point that I've come to, because if they did care, they would have listened to us and they would have changed everything. So actions, yeah.
Issue an explanation, an update.
Right.
Like, here are the numbers. We continue to whatever, something, not just silence in the face of this.
Right. So we'll have some articles linked below, and we'll link some of your articles too, Rich, because your stuff is, I said it before, but your stuff is excellent. Everything you write.
Thanks, Jeff.
Okay. So we have Scott in Burlingame. I have a tenant who's paid rent through March 2022. Yes. But in March applied to the CA COVID Relief Fund. No April rent. Are they protected from eviction because they applied to the program?
That's a great question.
I love it. Yes.
That is the one that I was going to address. So I'm glad somebody actually brought that up. It's unclear. I don't know that the Emergency Rental Assistance Program will cover future rent on a tenant's application that says, basically, I don't think I'm going to be able to pay rent in these months. But the way the statute's written, if they have an application pending, then you're back going through the same process, which is to say, you need to either get a final decision saying they're rejected, denied, or the program's out of money, or that's pretty much it. Now that you have information that they have submitted an application, even for April, May, June rent, you still have to give them the benefit of that application being processed.
Yeah, that's a very nuanced question, because if he had said that because they paid through March, so how can they apply? You can't apply for April rent with that program. You cannot, from how I understand it, you cannot.
Well, I'm sorry, I didn't catch the previous person you spoke about, the Housing is Key representative, because that would have been the question for that person, for sure. Right.
So you can definitely watch the video, everybody, but it's for the period up until March 31st, the way that I understood everything that you said.
The answer to that.
Right.
All I know is that the way the statute's written, pardon me, just to complete that, the way the statute's written, that the court will not let you proceed if you cannot declare under penalty of perjury that you have no information that the tenant has submitted an application. And even if it's for future rent, you can submit that and let the court figure it out. But I think the court would just go to the statute, and it's just simply says if there's an application pending. They don't really say for what period.
Right. Yeah. So because of that, I would say that one would be tough. But if they hadn't applied, hadn't paid April rent, they're not in Alameda County, they're not in Oakland, and they're just under regular state.
Right.
Then
you would
they would be able to go
the old days, so to speak. Non-payment rent, 3 business days, and then if they fail, you're able to submit a declaration that says, there's no application pending because the application period cut off March 31st.
Right. And also just to say, if you have the old AOA 3-day, definitely get the new one that has been updated just a few days ago, because there's new wording that has to be in there. It's just a little line, but it needs to be in there. And so definitely get the new one if you're operating off of something from before. It's just always good to clear out the old stuff and just make sure you're getting things off the website. Yeah. And okay, thank you, Scott, for that question. And then Jerry in Fremont, I was talking to one of our members, and you could almost call that free Fremont, because everything here. 10 units. I have a tenant who hasn't paid since last year, including the 25% is mandated. He is now working full-time, yet still isn't paying. Is breaking the law, and can I start eviction proceedings?
All I can do is have little tears run down my eyes for you, because, again, tenants who are abusing this particular provision are protected in Alameda County. And again, if you have an opportunity, you can go into the federal website and you can or you may be able to get it from AOA, and I can provide a copy of the lawsuit, and you'll read some of the plaintiff's stories, much like yours. It's just, that they're kind of heart-wrenching in terms of the impact on the property owner of this blanket prohibition that is just not justified, particularly in those particular cases. So unfortunately, you may be able to start proceeding, and this is probably should be a subject of a separate seminar on the collection process. You can't evict, but you may be able to start seeking payment through the small claims process. And if you get a judgment, you're going to eventually, if it's a working tenant, you're going to get paid. I mean, you can garnish wages, you can, take a variety of collection actions.
Right. And all this is all debt that's stacking up for people, and they think they're helping people, and really they're setting people up for total failure.
I'm going to guess there's going to be a bankruptcy wave following the lifting of the protections and so on. But again, that may be a separate seminar, though, because the repayment period thing is also really convoluted and complex.
Okay. Keywan's full. Let's see. I have a tenant renting an SFD in Fremont who does not pay rent since 9/2021. The tenant makes over $100,000 and simply refuses to pay the rent.
Same answer.
Yeah.
I'm sorry. If you're in Alameda County, you're just, I hate to say it, screwed.
Right. And Ruby, when can evictions for non-payment of rent in Oakland resume?
Well, now you got two layers. You have the Oakland version and you have the Alameda County version. So they both have to come off. But that's why this federal lawsuit names them both. I'm surprised it didn't name Berkeley, though, actually.
Okay, Marty on YouTube. Can evictions start in Hayward, Oakland for non-payment of rent? You've already answered that. How about health and safety? The courts are taking months to respond to expedite requests for evictions. What about health and safety? Is there any case besides non-payment?
Yeah. No, public health and safety cases, I have had a couple of those, and they've been processed by the court. So, the Alameda County is, the unlawful detainer department is in Hayward, and there's an unlawful detainer department, the 511, Judge Kolakowski. She's new. Actually, she just got put in that position a couple of months ago. But they don't happen overnight. But I mean, I have a case in Sacramento County that is, I submitted a request for, just to give you an idea, I think the landlord served a 3-day notice in November. We filed the unlawful detainer in early December, finally got the tenant served in early February, submitted a request for default about a month and a half ago, and it's still being processed. I mean, that's just unheard of. That's just unheard of. So Alameda is doing much better than that, at least if you have a public health and safety basis to proceed on.
Right. When you have a public health and safety basis, this is stuff to take to the media, because I don't put up with, if there's a real health and if there's a real safety issue, I mean, I would take it to the media and just shame these people for this type of, it's a reckless policy. It really is. And you should be able to get this through the court,
I mean, I want to make, maybe I wasn't quite clear, but no, I think Alameda County is processing public health and safety unlawful detainers at a reasonable clip. It may take, I mean, it shouldn't even take a week, because if you're talking about true public health and safety measure, and the police, I hate to say it, are not providing much assistance. If you have a violent tenant or someone who's, damaging or threat, I mean, it's a little wild westy out there, but they are processing those unlawful detainers, maybe within several days, something like that. And once you get your summons issued, then it goes, lickety split, just like it used to, which is to say you get the tenant served, they have 5 days, business days, if they're personally served, to file a response. If they don't, you submit your default request. Again, that instance I was discussing in Sacramento County, I hope that's just an outlier, but I think Alameda County is doing much better once you actually get your case into their system.
All right. Richmond, California, Contra Costa County, fourplex apartments. Where can I get info about Richmond? I have a tenant that moved out owing. I applied for housing as key and they reached out to her. When can I file?
Well, if the tenant moved out, if the tenant moved out, I mean, you've recovered possession, so at least you've stopped the bleeding. I mean, obviously that's the number one goal, I think. As far as collecting, I think the rental assistance program, continues to process even if the tenant's vacated. I mean, I think that was stated. And as far as whether the tenant cooperates, that to me is the real wild card, because I think the tenant has to cooperate. If they don't, of course, if they don't cooperate, then they can be subject to eviction if they're not in Alameda County. But if they've already moved, but if they don't cooperate, I mean, again, you get a judgment. But if you can't, gone. I mean, in some cases, it's just going to be a business loss.
Right, and they can, if they've moved out and that person did not claim COVID hardship, it seems like that can be, you can report them to the credit bureaus and send them to collections.
Well, sure. You can, if you can find them first. I mean, you have to serve people in order to get a judgment. As far as the credit reporting, that's something I'm not really very savvy about in terms of just submitting, hey, this tenant left owing money, and whether that goes on their credit report. I mean, I guess it does. I'm more familiar with the process of getting a judgment for unpaid rent, and then that becomes a device upon which you can compel payment if you can find the tenant and they have any money.
Right. Getting the judgment's much better, because then when you do go to collect it, it's easier to collect because they cannot dispute it at all.
It's a powerful tool.
Yeah. And then actually filing that judgment is also a step that sometimes people miss, but it's good to have that on their record. Just so other people can see that.
The thing about judgments is they accrue statutory interest at 10% annually. And so if the tenant hasn't fled the area, I mean, you can record an abstract of judgment in a county. And if they ever own property or try to finance property, they'll have to pay that judgment. And it accrues 10% interest. So it's not a bad investment, but you have to have the judgment. And also note, they expire after 10 years. And, you'd be surprised how many people let them lapse because they kind of forget. But after 10 years, the judgment will expire and will not be collectible anymore. So you have to go through a little process called renewal of judgment if you get one. So it's not a waste of time.
And, on the AOA, we call it the double whammy eviction report. And we have two different companies that provide it. That's why it's literally two different reports. But one of the things that's on there is the civil judgments. So you would see civil judgments for people. Yeah, so that's powerful to use that. That's available to you as AOA members. Here we go, Michael and San Luis Obispo County under AB 2179. Can we start evictions for tenants for non-payment of April 2022 rent, even if they've applied for rent relief for the time period before April 2022?
So that's a variation of the previous question. So you don't have any. It's hard to say if their application includes April, as we just discussed with the caller from, I think, Burlingame. The tenant says, "Hey, I'm submitting an application for rental assistance," and I think in that case, as in this case, you're going to have to just let it be rejected, either because they're not providing assistance for periods after March. But I think as far as doing your declaration on a penalty of perjury that you don't have information of a pending application, you'd be on a little thin ice there.
Yeah, right. Yeah, if it was a clear cut, there's no indication that they have COVID hardship, right. No. And it was April's rent, you could go for it.
Yes.
And it would just use the newest form that we have for the 3-day. Right. And that's how we're all seeing it right now. So, okay. Contra Costa County. Can I evict a single tenant on a shared rental agreement? I would like to move the troublemaker only. Each tenant is liable for their portion of the rent and pays me directly. This is a good question because it's one that you can answer, and it's not. So
I don't believe Contra Costa has a blanket moratorium. I'm pretty sure that expired. Right. So you can proceed against an individual tenant in a unit.
So you don't have to evict both of them at the same time?
No.
Okay. Chad on YouTube, City of San Jose. I would like to evict the tenant for non-payment of April 2022 rent only, just AB 2179 protect tenants from evictions for April rent. We both applied for rental relief prior to March 31st. So you covered this one.
Yeah.
And San Jose is, different. They're not under
No.
anything right now.
The only question is how that application that was made before the end of March is going to apply to future unpaid rent for April, May, or June. And again, I just don't know the answer to that one.
All right. Okay, Yin Lin, apartment, City of Berkeley, Alameda County. Tenant hasn't paid rent since September 1st of 2020. We did contact the tenant, but he did not give us any response. Can we file an eviction? And you've said it. No, not possible yet. So.
No, Jeff can answer this one.
Yeah, well, All right, Karen, Contra Costa County. Do we serve the standard 3-day notice for April when the tenant is late, but has her application in before March 31st? Man, everybody's asking the exact same question.
Yeah,
so that's good.
They probably put him in before that first answer came out, but yeah.
Exactly.
Right,
and that's okay. That's okay. In Alameda County, approximately what percentage of unlawful detainers go to jury trials?
Oh, tiny. I mean, I've been doing this for 32 years and probably have had, 10 jury trials in that period of time on unlawful detainer cases. I think I got a couple coming up, quite honestly, but they're really the exception, the great exception to the rule. I mean, because both parties realize that settling and getting something is better than the chance of getting nothing, and worse than nothing. If you're a tenant, if you settle, you get an orderly departure generally, because settlement means you're going to figure out some way where the tenant either comes clean and pays the rent over time, those pay and stay settlements, or agrees to have the rent waived and move out. But the consequence of going to trial and losing is you get, one, an eviction judgment on your record, which is really, a bad thing. And secondly, you actually have a sheriff come out and remove you from the property and all your stuff. I mean, that's just like no way to leave a place. So most tenants get it. And landlords agree to waive the rent because they just know they're just throwing good money after bad. I want to go to trial. Like, no, you don't. It's just not worth it.
Now sorry, I thought okay. Now what would you say about raising the rent? I know that usually there's two types of questions. One is, can I evict? And the other one is, can I raise the rent? So where can you raise the rent currently? Where is it legal? Where is it unpermissible?
Well, I know that Alameda County's moratorium does not include prohibitions on rent increases. They left that alone. Oakland has a current restriction to the annual CPI, so you can't do bank rent increases. As far as petitions for like capital improvements, I'm not really sure. But it really depends on where you are, and you just need to have somebody specifically look into wherever you are. But Oakland is the only place I know of right now that has a rent increase limitation. I mean, beyond their normal rent increase limitations.
Right. All of them have limitations, but just not there sounds like severely, meaning there's no way. Increases.
Well, like I say, Oakland allows the annual CPI, which is increasing, each month, basically.
Okay. All right. So those are good. And you need to serve, give notice for the rent increase and all of that. So here's Patty. Here's Patty on YouTube. It's a 2-unit, lower tenant not paying as of November. Applied for California rent relief. Top tenant is a Section 8 and not paid their portion for a year. Refused to apply for assistance. Are there any eviction options?
Well, depending on where it is, obviously, if we're talking outside of Alameda County, Section 8, how Section 8 falls into this is, I assume they're also entitled to, submit applications for assistance. But otherwise, I think you would, evictions of unlawful detainers involving Section 8 tenants are a little more complicated because you got to do a little bit more compliance with the federal regulations, but it's not, it's not onerous. It's just something a little additional. And they're usually exempt from local rent control laws. So for whatever that's worth, because the rent's set by the housing authority. So no, otherwise they're treated pretty much exactly the same.
Hey, I'm really looking forward to seeing you in person, and in June in Oakland. If I remember right, I believe we're talking about the end of June, and so I believe we're looking at the 23rd. And
in-person seminar.
Yeah. So finally, we'll be able to do that with you and meet you in person, because I haven't met you in person yet. So that's going to be neat.
Look forward to it.
Yeah, so
that'll be members in the audience again. Quite honestly, I'm tired of looking myself. I mean, I'm staring at myself right now. I was like, I'd rather look at the happy faces or some not so happy faces.
Right. I can't wait to meet everybody. And so that's coming up. So just watch your AOA magazine for event details, but that is coming up. I should have mentioned that before we went into the Q&A, but here we are for those of you that listened, and here you'll be looking for it, and hopefully you'll be able to register, because it's limited to 70 or 80 people because of the venue. And so we were able to reach so many more people with a live stream here. But thank you everybody for joining us. And, the best thing is just to be persistent with these officials. And I think calling a lot and giving details and sending it to more than just one person. Send it to all the county supervisors, send it to all the city council members, and, just go for the senators, keep pushing. And,
you can go to the state level and see if you can get a little traction there, and have them, even though they don't have much,
yeah, I mean, I just might as well include the kitchen sink. I had a guy that included the fire department, and just, all kinds of people. And anyway, so there's lots that seems like it's beyond our control, but I think if everybody, we're really into grassroots advocacy. And so just if everybody is letting their voice be heard, it will only help us. Mm-hmm. And silence is to our detriment for sure. And so freedom is always something that is fought for. And we civilly, not violently, but fight it with a pencil. With the pen and paper, or with the phone, whatever it is. Let your voice be heard, and we have different resources if you need talking points. And we have the political
vote.
Yeah, and voting. Yeah, voting is obviously
their terms do come around.
That's right. So anyway, thanks for joining, everyone. Thank you, Rich, for sharing with us. As always, you do a great job, and we're very thankful for you.
I'm happy to have the opportunity.
Okay.
I do look forward to seeing the members in person before too long.
Yeah. Okay. We'll talk to you. We'll see you guys next time.
Right.
Okay, bye-bye.